guys, this is your video lecture on the HIPAA notes that were posted in Module 3. So I'm going to scroll down to Module 3, the week of 3/25, and within the HIPAA book, click on that. You're going to go over to reading. Here are the notes. They were embedded. Hopefully you haven't had any trouble finding them. And we're going to open up the notes. And so these notes are 8 pages of excerpts taken from another book. They are written in little blurbs, as you can see, and we're going to hit some high spots in these notes. So it's important that you understand what HIPAA is and what the acronym actually stands for: Health Insurance Portability and Accounting Act of 1996. And what HIPAA started out as, interestingly enough, was portability for folks that moved from job to job, portability of their health insurance. Then it ballooned into privacy and evolved into what we know as HIPAA today. And HIPAA is wide-reaching. You know, we're going to have medical records take on it, but anytime you've seen a privacy notice from your credit card or debit card company, anything from your bank regarding privacy, anything like that, it's all driven off of HIPAA. Let's see. Let's look at number 2. Who must comply with HIPAA? All health plans, clearinghouses, and providers that transmit standard transactions in electronic formats. These organizations are known as covered entities. That's a very important term, covered entities, or CEs, as you may find some places referring to someone being a CE or a covered entity. So if someone falls under the umbrella of a covered entity, then they must comply with all the rules and regulations with HIPAA. And then number 3 gives you a definition of what a healthcare provider is. HIPAA defines a healthcare provider as a legal entity that is trained and licensed to provide healthcare services and that transmits identified standard transactions electronically. So you're picking up on that. Between 2 and 3, we're talking about electronic transmission of any data. Here in 2019, you know, when this was written in 1996, if your institutions accepted payments via Medicare and Medicaid, you were transmitting information electronically. But beyond that, there wasn't a lot of that going on. But now in 2019, we know how much we're transmitting electronically. So this covers a wide variety of healthcare institutions now. Okie dokie, so let's take a look at number 12. You'll notice that the numbers skip around a little bit, but I've again gone and grabbed some of the more important things. So you've already picked up one main term, which is a CE or covered entity. Now we're going to move on to what information is protected by the privacy rule. And this shouldn't be a brand new term for you, but in number 12, it introduces you or reminds you of information called PHI, or protected health information. It's information that relates to past, present, or future physical or mental health condition. So basically, any health information is considered to be protected. We're going to learn in release of information what we can release under the HIPAA rule and then what the state of North Carolina allows to release. But generally, let's just throw all health information under that umbrella right now, and then we're going to break that down. So PHI, if you're keeping a list of important terms, add that with CE or covered entities. So number 13 says, in what instances may a CE use and disclose an individual's PHI? So here, 13, if you've printed this out and you want to star it or highlight it, it's very important. So covered entities may use PHI for the purposes of treatment, payment, and healthcare operations without obtaining an individual's authorization. Now, we haven't really launched into release of information yet, but the The general rule of release of information is that you need the patient or the patient's representative to sign an authorization before health information can be released. HIPAA allows for treatment, payment, and healthcare operations without obtaining that individual's written authorization. So I'm going to give you another abbreviation. You're going to find this referred to also as TPO. So TPO, treatment, payment, and operations. Treatment is pretty straightforward. That means we can release doctor's notes from physician to physician for continuation of care without the written authorization. Payment, we can release information as it relates to getting the bill paid to an insurance company without the patient's authorization. Healthcare operations may be a little different for you to understand. Healthcare operations just means the use of the appropriate use, I should say, of a patient's PHI for an intended purpose. Okay, for example, so let's say you've got a patient that is interested in filing a lawsuit against a doctor in your hospital. Because of that, the hospital would have authorization to access the individual's PHI for that purpose. Other instances are for research, for peer review, anything like that that falls under healthcare operations. We can use their health information without their authorization as long as it can fit into T, P, and O. Treatment, payment, and operations. If we can define what we're using the information for that purpose, we can use it without an authorization. So very important. That's the basis of release, and we're going to be covering that real soon. Okie dokie. And number 14 says, in what instances must CEs limit the uses and disclosures of PHI? And the privacy rule says that CEs must use the minimum necessary. Big, important words. Minimum necessary. So exceptions exist when PHI is being disclosed for treatment, is being disclosed to the individual, and or being disclosed to the Department of Health and Human Services. So what is minimum necessary? Minimum necessary means what needs to come out of that visit that is the bare minimum to meet the requirements of that disclosure. So if you'll remember back when we talked about subpoenas and we talked about attorneys liking to have any and all health information that is related to a visit, that's not the minimum necessary. So what we're looking at as far as the disclosure is concerned to whomever is that we need to send the minimum necessary to carry out for that intended purpose. So if your insurance company contacts you on a patient's visit and they're looking for a little more notes to make sure that the patient's x-rays were actually coverable for a particular visit, we're not going to send the entire record. We would just send x-rays at that point. So keep in mind what minimum necessary is once we start talking about release for sure. So now you've got on your list CEs, PHI, TPO, and minimum necessary if you're looking for keywords. Alrighty, so, oh goodness. Alright, let me show you. I should be able to rotate that so we can see it. 22 talks about what does TPO stand for, which we just covered, so that's super important. Healthcare loves an acronym. Number 23, what is patient consent? Under HIPAA, consent is written permission to use and disclose PHI for TPO. And it just talks about exactly what a consent is, because in 24 we're going to talk about what an authorization is. Alright, so 24, an authorization is a detailed document that gives covered entities permission to use PHI for specified purposes which are generally other than TPO, or to disclose protected health information to a third party specified by that individual. And so that's a little broader than consent. All right, so if you're taking a look at number 25, what permission must be obtained from an individual before a CE discloses protected health information for purposes other than TPO? So, except in certain emergencies and as required by law, which I want you to think back to those mandatory reports that I posted in your notes, an individual must sign an authorization form permitting the CE to disclose the PHI. Again, the HIPAA privacy rules list specific information that must be included in that authorization, which we're going to look at in number 26. And you have your first module assignment that relates to that also, verifying whether the two posted files are actually HIPAA compliant. So we know in emergencies that when we talked about your consent chapter before spring break, that we learned that there's implied consent in emergencies. If you've got an unconscious patient that needs to have some kind of work performed on them. Disclosure of PHI is a little different. We can bend the rules in emergencies, but again, we're really looking for emergencies to try to fall under TPO, right? So if you've got a patient that is your normal current patient that happens to be on vacation somewhere, they are unconscious in an emergency room where they are on vacation, definitely that would fall under TPNO, right? So other than certain emergencies and mandatory reports, we are really looking to have a specific authorization signed by the patient or their representative. Okay, so number 26 goes over what information must be in an authorization to comply with HIPAA requirements. And I'm not going to read through that necessarily. We're going to hit some high spots, but the core elements should include the bulleted list that you see below. So what you'll find with files is the files that I've posted is that the way that they look doesn't necessarily matter. You know, we may not prefer one authorization over the other, but we're generally looking to make sure that each of the authorizations has what's listed here. So let's talk about this particular bullet right here, redisclosure. We haven't talked about redisclosure yet. Redisclosure is just big and fancy for using the information that is provided to you without patient consent. So when we release information, we are complying with the authorization that we've been provided. And what we like to say to the patient is once we provide that information to the recipient, we're not really bound by what the recipient does with that information, if that makes sense. You know, our hope is the recipient of the PHI will follow HIPAA requirements, but beyond our initial release, any redisclosure, we're not liable for it. So that's essentially what we're saying right there. All right, so let's scroll down to number 31. In what instances may a CE use and disclose PHI without obtaining a written authorization or allowing an individual to object? So a CE may use or disclose PHI without the written authorization of the individual in the following circumstances. And so number one, uses and disclosures required by law. Again, I'm going to point you to the listing that I gave to you in your notes, and those are specific to North Carolina, right? We already know about TPO. We learned that at the beginning of the notes, that if we can have the disclosure fall under TPO, we do not need the patient's authorization. Also, uses and disclosures for public health activities, which in the state of North Carolina happens to fall under lawful mandatory reports, as a lot of these do. So, victims of abuse, we talk about law enforcement, we also talk about donations, tissue donations, research, anything for safety, and then disclosures for workman's compensation. So we'll get into the workman's compensation laws in the state of North Carolina and how disclosures work once we start talking about release of information. And we'll break down some of these other ones too. Disclosures for law enforcement, disclosures for judicial and administrative proceedings, so you understand how it works in the state of North Carolina. Number 32 said, are CEs required to limit the disclosures of PHI to the minimum necessary when requested by a subpoena? And the answer is no.